Welcome to the Board of Education's April 18th, 2022 called meeting. Please stand as we observe a moment of silence followed by the Pledge of Allegiance led by Ms. Henderson.
Please stand for a moment of silence. Please face the flag. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
So, board members have been asked to remind everyone to please speak into the microphone. Can you hear me? Oh, it doesn't seem loud to me. Okay. Since this meeting was called specifically for the purpose of mediation, and we don't really have an agenda, mediation is the agenda, so we will need a motion to approve and to vote on that. So a motion by Ms. Horn, a second by Mr. Watson. All in favor, say aye.
Aye.
Any opposed? Motion carries. Again, the meeting was called specifically for the purpose of mediation on the mask mandate lawsuit. There are special rules that must be followed. The rules have been posted in multiple places throughout this facility, as well as on the table in the back of this room with the meeting agendas. Please be sure to review and follow them. I am going to ask Mr. Dupler if he could speak more about the procedures and process of how this day may shape that.
Oh, yes. Thank you, Madam Chair. So today, as Madam Chair stated, you all are in mediation. So this is not going to be a normal meeting. There's going to be times when you're in here deliberating, and that's going to vary throughout the day. You could be in here for several minutes. You could be in here for an hour or more. It just depends on what your discussion is. Okay, you're going to be back and forth, but between executive session with our staff and you know, talking about or getting feedback from the mediator as well. But of course, any deliberation amongst yourselves must be done in this room. And again, we don't know exactly how the schedule is going to go. We may leave here and be gone for quite some time, hours, or we could be back fairly quickly. We just don't know. Questions?
Yes, I have a question. And is this one? Mm-hmm. Okay. When we're in here, will the mediator be speaking to us, or will the mediator only speak to us in executive session?
I think primarily the mediator is going to speak in executive session because again, the mediator can talk to you. You can even individually maybe ask some you can ask some questions of the mediator, but you can't deliberate amongst yourselves. But there's nothing to say that the mediator couldn't come in here if he so chooses.
Thank you.
So, are there any other questions? Okay, so we will call a recess. Okay, we are back in session, and Chancellor Fansler is going to read to us the offer made by the plaintiffs so the public can know. And I think they wanted you to face Justin. Which does he need to face back that way too, since it's okay? Thank you.
I had to be sure I didn't step up here and say, "May it please the court." As you know, we're here pursuant to order of the Federal District Judge Ronnie Greer regarding the case of SB versus Knox County Board of Education and Governor Lee, which has been referred to as the mask mandate case. Offers have been made, and we of course are, because of the nature of the public meetings law, doing a parallel negotiation with the state and the plaintiffs and the board with the plaintiffs. So this offer that I'm about to present to you represents a settlement offer between the Knox County Board of Education and the plaintiffs. The first thing I will mention is that This offer would bring this litigation to a complete halt. The injunction that's currently temporarily dissolved, I think, would be permanently dissolved. There are certain items that the plaintiff's lawyers had originally proposed to charge relating to a motion and memorandum on compliance with the existing temporary injunction that would be omitted from their demands. The court has the right to take a lawyer's hourly fee and, based on the nature of the case, put some enhancement factor to that. In this case, there had been an enhancement factor requested, and the plaintiff's counsel is now willing to waive that enhancement factor. Of course, this is an act. I'm sorry. All right. This is an act pursuant to the Americans with Disabilities Act, ADA, and the prevailing party in those cases is entitled to recover attorney's fees. Judge Greer's order is currently on appeal to the Sixth Circuit Court of Appeals in Cincinnati, and as I understand, is set for a hearing on May 4th. If this case settles today, not only will the existing claim for attorney's fees be satisfied, but it would enable the board to avoid the exposure to any additional fees associated with the appeal to the Sixth Circuit, and also if you were not successful on the appeal and the case was remanded to the district court, then of course there would be ongoing proceedings there. Not the least of which is the possibility that the court could exercise continuing jurisdiction over the Board of Education regarding the masking policies of the Knox County Board of Education. And there's no way to forecast how long that continuing jurisdiction might exist. We can't even give any kind of reasonable expectation as to when COVID-19 might not continue to pose a threat to all of us, in fact. As part of this settlement, the case, as I said, would end totally. The case would be dismissed in the Sixth Circuit Court of Appeals. The case in the district court would be dismissed. It would require payment. Of course, we can work that out, a payment within 10 days of the court dissolving the injunction. Now, a proposal has been made by the plaintiffs where the fees incurred prior to December 10th, 2021, and that's the date that the state dropped its appeal to the Sixth Circuit. And I may have some of these terms wrong, Mr. Dupler, but I think that's the date that's referenced. Thereafter, fees incurred from December the 11th of 2021 forward would be borne by the Board of Education. The total amount being claimed at this time by the plaintiff's attorneys is $185,425. Of course, they also ask that the board pay the fees of the mediator associated with this through the date of the execution of the settlement agreement, which would hopefully be today if we reach a settlement. As I said, the governor is not a party to this particular settlement, but his representatives are here, and I will be working with them throughout the day as well. This is a case that, like the issue all across the country, is fraught with disagreement between those who think certain things should be done and those who think certain things should not be done. I urge you to look at this case as not a political case or a policy case, but a case that you're considering pursuant to the provisions of the Americans with Disabilities Act, along with the judge's order, with the expenses involved in the appeal to the Sixth Circuit, and and all the attendant matters. It's a matter at this point of bringing this particular lawsuit to an end, and terminating fees that you might owe that have been incurred, and fees that you might owe that would be incurred going forward for a period of time that's uncertain. So, do I have any questions from anyone? I'll be right here, close by.
Mr. Watson has a question.
Not
Okay,
a question,
Ms. Watson,
Madam Chair. I'd
sorry.
like to make a motion.
Oh, okay. Okay.
Could I ask something before the motion? I know you brought the one point up about the amount of money, but aren't there like 4 other points? I mean, do we need to know those or not necessarily?
In terms of the outcome?
The demand that's in
The
question.
demand
Yeah,
from the
well,
plaintiffs.
there was 1 or 2 other things. Right now, as the process goes, I know as a mediator, certain times that I should be raising issues and certain times that I can't. So let's focus on what we might be able to agree upon right now.
Okay.
And of course, the one thing I think you may have in mind, as far as I'm concerned, is more of a policy issue, and that is something that I want to avoid today, if we possibly can do so. That's your prerogative going forward, what you all choose to do if this circumstance should arise again. And of course, part of your deliberation here today is whether or not that process going forward is going to be in your control or that of the U.S. District Court judge, whomever that may be, if Judge Greer retires.
Thank you.
Any more questions? Mr. Watts?
Thank you, Madam Chair. I'd like to offer a motion for discussion and possible action regarding the demand that the chancellor's brought forth from the plaintiffs in the current mass case. Discussable and possible action.
Okay. Do we have a second, or?
The motion is to discuss the demand and possibly have action regarding the demand. You need a second? I'll second. Yes. Okay.
So a motion by Mr. Watson, a second by Mr. McMillan. All in favor? Aye.
Aye.
Any more discussion on that? Okay. All in favor? Aye.
Aye.
Any opposed? Motion carries. So,
Want to start?
who wants to start? Gary, do you have anything to? Would
Well,
you like to start, Gary?
I can, Madam Chair, and I'll just tail on what Chancellor Franzler's already shared with you. I mean, the basic demand of the plaintiffs is for this amount of money, and dissolving the case. I mean, dismissing the case in total. That would be both the Sixth Circuit and the District Court case. There are some other small issues that we can talk about, but that's the real basis of the demand. So at this point, this board, it's on you to discuss, do you want to make a counter offer to that demand? And if so, what are the terms? And again, I mean, the 2 basic ones that are laid out is dismissal and money. So.
I guess I'll start. I definitely would like to counter that amount, and I think we just need to look at a lump sum of what we would like to do. I don't know if this is so awkward. I'm not really sure how we do this, if it's up to kind of one of us to throw out a number at this point. I mean, I guess I'm going to throw out like $100,000 at this point for starting discussion as to whether we want to, as a starting counter to their demands. Anyone else?
I can say that I was going to throw out 75.
For what it's worth, I was also at 100,000. That's what I had written on my notepad.
And I would agree with Jennifer, 75,000 as a starting point.
point somebody should make a
And,
motion
well,
about an
and,
amount?
and I'll just, again, I'll just tell on that, which is, obviously, this board is looking at some type of a compromise. This is a compromise. I mean, when you're in mediation, nobody's gonna walk away. I mean, neither side, neither this board nor the plaintiffs are gonna walk away with exactly everything they want. That's what the litigation's for. So for this mediation to be successful, there would have to be some type of compromise, but go ahead.
Well, and I would just like to add, I mean, I can't speak for the rest of the board, but me personally, I don't think we want to take the risk of putting this in a judge's hands for 2 more years running the board policy. I mean, I think that's a concern if this continues moving forward. I think while none of us are happy, and I think we've talked about that, mediation is probably neither party is completely happy. I do think we would like to see this lawsuit go away, and I think that's what this mediation allows, and that's what I personally like about this, is it settle it. Does it settle the future for us and what other people can do? It doesn't. I mean, we hope, we hope for the best, but I mean, nothing we do and with this lawsuit is going to prevent other things from the future. So I will make a motion. I'm actually fine with the lower amount. I would make a motion to offer the plaintiffs $75,000 in legal fees.
Second.
So we have a motion by Ms. Babb, a second by Ms. Owen. Any more discussion on that? Mr. Watson?
Thank you, Madam Chair. I think in some ways we're kind of just throwing a dart at a board, but I don't know that starting at less than 50% of what's being asked is a reasonable counteroffer. I just don't know that that's a good starting point, mainly because I can't imagine they're going to accept it. So I'm trying to limit the amount of times that we actually go back and forth, and I think starting less than 50% might be a challenge. So, and again, in some ways, I think you're just kind of throwing a dart at a board. I mean, I didn't base my $100,000 on a particular, strategy or reasoning, other than I thought it needed to be greater than 50%. So, but.
Yes, please. Please.
I don't tell parties how much to offer. I do give you some tips on how to make your offers. I think that it's an excellent point that starting at less than half is not likely to accomplish anything, but it's a starting point. I mediate cases where people start with ridiculously high numbers and spend the day negotiating what I call nothing but air. They don't get down to the real money until late in the day. In my opinion, the amounts that have been thrown out by the plaintiffs, they're certainly negotiable. You're free to start wherever you want to start. These fee requests are not totally inconsistent with what the district court has done in the past on similar requests. As I said, the amount is negotiable, and our process is a give and take process, and we start somewhere and we get somewhere to the end, either impasse or settlement. I'm very optimistic about the mediation process and think that settlement has a much greater possibility than impasse. So, having said that, we can start wherever you want to. It will prolong the process. You will get some counter from them, and it's a little cumbersome the way we're doing this. You'll have to come back into session and consider these negotiations, where it would normally take me about 10 or 15 or 20 minutes. It could last a whole lot longer. So, having said that, I'm going to sit down and let you all finish your deliberations then.
Thank you.
Okay, so we have a motion and a second at this point.
And yeah, so if
So,
I may.
yes, please.
So yes, we've got a motion and a second. One thing that I would ask the board to do, I can't ask for a friendly amendment, but you all can. I mean, if you're offering the fees, that's one part of it. I think the other part of your offer needs to be a complete dismissal as well. That's the other thing on the table. I mean, so you need to put that out there as well, that, you know, if that's what you want, you know, everything dismissed at both courts, then you need to ask for that as well.
Can I amend my own motion?
Yeah.
Okay, I would like to amend my motion to offer $75,000 and that this case is completely dismissed. Is that sufficient? Okay. And who's second?
I did. Second.
So we have a motion by Ms. Babb, a second by Ms. Owen. Ms. Owen?
Thank you, Madam Chair. I would like to point out that the number that I came to at 75 is based on what we consider, what I would consider a more reasonable fee hourly, even though we're looking at it as a lump sum. I think we could discuss maybe going somewhere between 75 and what would be half would be 92, half of what they ask. And if we went halfway in between there, we're looking at about 88. Does that make sense? So half of what they have asked is 92. Half of what I'd consider more reasonable fees would be 75. And half of that, I mean, the midpoint is 88.
Ms. Horn?
Thank you, Madam Chair. So is this on?
Get up real close.
Okay,
You gotta
it
eat it a
sounds
little
so,
bit.
so different. So for the folks that I represent, I think to offer money at all is a hard pill to swallow. And so that weighs very heavily on me because our students and our staff have really gone through a lot this year because of this. And so, you know, it's always a concern of mine anytime you hear of someone settling in a case that admits guilt or whatever. So so that weighs very heavily on me because I feel like that we have a lot of families that have endured a lot of hardship this year. At the same time, I'm very concerned about what could happen in future court proceedings, and so I would certainly be more inclined with a lower number to begin, since it would pain me to vote for any dollars whatsoever. So that's kind of where I am. I would definitely be in favor more of a lower number. So.
Ms. Henderson?
I completely agree with Ms. Horn. Our children have lost a year of their lives because of this. We have children that are struggling to read. So giving these attorneys any amount of money is really hard for me when we could put that towards programs for literacy. So I agree completely with Ms. Horn.
Mr. Watson?
Did you have something?
Okay. Mr. McMillan?
Thank you, Madam Chair. I hear what Ms. Horn and Ms. Henderson, I started to say Betsy, Ms. Henderson are saying, and you know, we never want to spend money that we don't have to spend. But having said that, I think we have to be realistic. I think the public will understand under this case that what's going on. And in light of that, I think my personal opinion is at 75,000, we're just wasting time. In light of that, I would like to offer a substitute motion, which would basically call for all the things that we've talked about, and the dollar figure would be $105,000, which I consider a reasonable offer. Thank you.
I'll second that.
So we have a substitute motion by Mr. McMillan and a second by Mr. Watson for $105,000 and a dismissal. Mr. Watson?
Thank you, Madam Chair. I agree that there's a lot that the public's going to probably take in about this process and and have a lot of different feelings, different ways. I think the board has been consistent in stating that we want to move past this, to the degree that we've even agreed to allow the law department to hire outside counsel and pay additional money in order to move this case forward. So I think anything that we can do to resolve it, the sooner the better. And I agree, Mr. McMillan, I think that's a reasonable starting place.
One additional comment along those lines. I think the public wants it settled, and they want it settled now, in my opinion. Thank you.
Okay, so any more discussion? Okay, and I'll just weigh in and say that I feel the same as far as the money amount goes. I mean, I don't even like the idea of $75,000. I mean, that's just, I mean, I get it, but because I still don't feel like we have closure even at that point. So we have a substitute motion by Mr. McMillan and a second by Mr. Watson for $105,000 and a dismissal. Right. So, Ms. Coatney?
Miss Owen,
Yes.
Mr. Watson,
Yes.
Miss Babb,
Pass.
Miss Horn,
No.
Miss Henderson,
No.
Miss Bounds,
No.
Mr. McMillan,
Yes.
Miss Christie.
No.
That's 3 yes votes, 4 no votes, and 1 pass. Miss Babb, would you like to change your pass?
No. Can I make another motion? So
that motion fails. So motion fails.
Does it go back to the original, or do I need to make
It
another
goes
motion?
back to the original at this point.
Okay, so I would like to come back with a motion of 75,000 and to end this case at this point.
That's the same.
Same motion as before.
Do we need a second or is that?
You've already got a second.
Okay.
Okay.
So we got a motion by Ms. Babb and a second by Ms. Owen. Ms. Coatney?
Miss Owen,
Yes.
Mr. Watson,
Yes.
Miss Babb,
Yes.
Miss Horn,
Pass.
Miss Henderson,
No.
Miss Bounds,
No.
Mr. McMillan,
No.
Miss Christie.
No.
That's 3 yes votes, 4 no votes, and 1 pass. Miss Horn, would you like to change your pass?
No.
So that motion fails. So do we have any more
Can I-
discussion?
Can I ask for discussion? For the people that did a no, I mean, is there any sort of motion you could put forward that you could vote yes for at this point? That's what I guess I'm asking for some people at this table. Is there any kind of motion you can put forward at this point? Yeah.
Yes, please.
Typically is something, well,
Yeah.
this type of conversation I'm about to have with you is typically the kind of thing I would sit across the table from one party or multiple parties sometimes and have. I want to address one thing about the notion that by settling a case, you somehow are admitting that you were wrong to start with. Let me point out a couple of things. You're certainly entitled to ask that any dismissal stipulate that no party is admitting liability in the case. That's a very common thing. number two, as distasteful as it might be to pay attorney's fees, the federal act provides for the recovery of those fees. The only possible way that you're going to avoid paying those fees, well, I won't say the only possible way. Let me say the most likely way that you would ever avoid paying no fees in this case is that if you won outright at the Sixth Circuit Court of Appeals and Judge Greer was reversed in total and ordered to dismiss the case. I don't think that's likely for a number of reasons. So, if you don't get the case dismissed at the Sixth Circuit, then not only are you likely to have the distasteful experience of paying some number less than $185,000 today, but an even more distasteful opportunity to pay quite a bit more than what you're paying today and continue to incur those fees if the federal court exercises continuing jurisdiction. So if you think it tastes bad right now, it could get real nasty before it's all over with. That's all I ask you to bear in mind. As I've pointed out at the outset, not only are personal feelings involved here, but political decisions and I won't say pressure, political interest of people. It's such a divisive issue. But the real issue for you all is what is in the best interest of the county, the Board of Education and the county school system as a whole. And you have to decide, is it good for us to continue to pay outside counsel of our own? Is it good for us to continue to pay, possibly continue to pay the plaintiff's attorneys? Is it good, is it distasteful enough to face the prospect of a federal judge running your system for the next 2 or 3 years, telling you how you're going to handle the COVID situation? Now, if you think that something less than $185,000 today is so distasteful that you'd rather have the alternative, then you can stay your position. If you think that, and if you think that's in the best interest of the county school system. But if you think that it's in the best interest to regain control of your system, and it's in the best interest of the school system to immediately cut the bleeding of lawyers' fees on both sides, then you need to consider a number that's a reasonable number that will settle this case. And we know that these types of cases, and this law firm in particular, have been awarded substantially more than the kind of money you're talking about in this first motion. And I also point out to you that you need to consider that this is a give and take process. Everybody has to give. If nobody's willing to give, you're wasting your time with me. You're trying to get the best alternative to what you're looking at going forward. And I've outlined the dark side of it for you. And the bright side is, you're in control. This case is over with. You're not paying lawyers. You're not paying me. You can go on about your business, trying to craft whatever you want to craft as your own policy. So, there's a lot more than $75,000 or $105,000 or $185,000 at stake in this case. And there's some number that, as distasteful as it may be, should be less distasteful than the alternatives that you might be facing. So.
Okay, thank you. And I think part of this is where doing this in a public meeting becomes awkward, because we could not, nobody knew what number anybody was thinking upstairs, right? Because we can't have those deliberations. So I do think maybe it would be helpful if Mr. Dupler or Mr. Bennett could, maybe talk about it a little more so we can have the discussion more openly than what we it upstairs.
I can certainly say something briefly, Madam Chair, which is, so you all have talked about two numbers. And again, this is, for mediation to work, it's going to be a compromise. You're not going to get this board's not going to get exactly what it wants. And for a successful mediation, the plaintiffs are not going to get exactly what they want. But from what I've heard just now, you all were talking about two numbers, and it sounds like you've got some disagreement on those two numbers. But if this board can come together and agree on one or the other, right? If you're willing to, you need a starting point for this process to even have a chance. So, either you all come together and agree on the 75 or the 105 or some number to get this thing going. Mr. Watson. Sorry.
Thank you, Madam Chair. Just to be clear, Mr. Dupler, I just think it's important for us to note that if we don't, there's nothing to take back if we don't have a motion that gets approved, regardless of what the motion is in this meeting and this process ends. And I think it is important to note, too, that we've been asked to come to this in good faith. And I think to not have a counter is regardless of whatever it is. If we wanted to offer $50, I'm not saying we should do that, but it seems like we need to have some kind of counter. And so I think I would ask what Ms. Babbs asked as well, for those who have not been able to get to the 75 or the 105 that was offered, is there some kind of starting point to move the conversation forward with the plaintiffs? Because I think everybody here has agreed that I think the public is over this. They do want to see it concluded. Now, how it gets concluded is one thing, but this is what this is the task at hand, is to mediate. And I agree. I don't know that we're going to get 100% of anything that we want here. And yeah, my feeling to Mr. McMillan is I think the public wants this done. So.
And Mr. Dupler, correct me if I'm wrong, but if we agree on this amount, that we can stomach this amount right now, and we go back and discuss the other items, the board would still have to approve that settlement in its entirety later when we come back, right? So this would just be a starting point.
This is no decision.
The complete agreement would still have to be voted on at a later time, right? Is that correct?
Yeah, correct, Madam Chair. So what would happen is, you all come up with the figure, whether it's 75 or 105, and a complete dismissal. If the plaintiffs were to accept that, hey, that's great. Do you all need to expect that? No. Again, this is a process. It's going to take some time. That's what Chancellor Fanzer's talking about. So, so don't expect the plaintiffs to even accept this offer. Expect them probably to come back with their own counter that you all will then have to discuss again. And if they're wanting some other type of language in there, you're not offering that at this point. All you're offering is an amount of money and a complete dismissal. That's all you're offering.
Ms. Owen.
Thank you, Madam Chair. I'd like to note that we've talked about this being a whole year, but we've also talked about if it goes on, it could go on for 2 more. And if this were to go on for 3 total years, we're looking at $500,000. So in the interests of being fiscally responsible, waiting until this accrues up to $500,000 doesn't make sense to me. So I'd like to make a motion that we ask that we end the litigation at this point and offer $92,000 in attorney fees.
Second.
I'd like to speak,
Okay.
please, if nobody else wants to.
Okay. So we have a motion by Ms. Owen, a second by Ms. Babb. Mr. McMillan?
Thank you, Madam Chair. I agree with part of what you said, Ms. Owen, except at 92,000. I know what the people that were stuck with 75, they're trying to keep it as low as possible. Now, this is the real world, and you've got to be realistic. We represent the citizens of Knox County, and it's our job to do the very best, whatever that entails. That's why I offered 105. I do not believe that your figure is any better than the 75. Therefore, I will vote against it. Now, if you're just going to sit here and play games all day, you might as well just get up and leave, in my opinion. Thank you.
I was hoping before Ms. Owen had made a motion, we could have the 4 people, because to be honest, we have to have 5 of us to agree to anything to go back. And this is where I'd address you, Mr. McMillan. Once again, this is just a starting point. I don't think anybody thinks whatever we send to them is going to go anywhere, is going to be the final. But we've had 4 people that won't vote on anything so far. 4 of us have voted at least on one number. So if we have 4 people that will never vote on anything, we need to know that. That's why I'd really like, I was hoping to hear from the 4 people that did not vote in the affirmative for either offer, because we need to know if there is anything that you'll go for, because if there's not, we can't get 5 votes. And so, so that's a little bit where, if we can't have at least 5 of us even making an initial offer to the other side, we aren't going. I mean, we can keep battling back numbers, and if we keep if we have the same 4 people that won't go with any of those numbers, we're never going to get 5 of us.
Could I speak to that, Madam Chair? I concur with what you're saying, and probably the reason is they fear bad publicity for paying out something. Let me tell you something, in my opinion. If you continue down the path of not voting for anything because you think you're right and you fear publicity, you're going to get publicity, and you're going to get more than you want, in my opinion. So, like I said before, if you all are stuck at something under $100,000, or you won't vote for anything, why, we're just wasting everybody's time right here. Thank you.
Ms. Bounds.
Thank you, Madam Chair. Mr. McMillan, I have nothing to lose with publicity, and that never entered my mind. As a former teacher and dedicating my life to students, that is where my heart and my passion and my mind is. And I can go on record. I think it's and I think maybe the public gets a sense of that now, how difficult this is. Because with all due respect to our mediator, and I have the utmost respect for you and your things that you've said and counseled us with, we're doing it out here in the public arena. You can go back to the plaintiff's room and have a conversation with the plaintiffs. And to me, that puts us, as we all knew it would be, I just don't think I realized the weight of that and how hard it was going to be. When one group has the advantage of a conversational thing, and we're out here trying to throw numbers around and come to an agreement. But whatever decision I make, I can assure you it has nothing to do with publicity. I've been on this board too long and endured too much negative publicity to worry about that now. But it does have to do with the students of Knox County, and it's not the past, it's going forward. And therein is where I'm at. And the money is one thing, the dismissal is another matter, and we've got them both there right together. So thank you. I did not intend to speak, but I just want the public to realize how difficult this is.
Yes.
Thank you, Ms. Bounds. I appreciate your comment. For those of you who are not familiar with the mediation process and what a mediator does, I'm sort of the guy that wears the black hat. I talk to you about the bad side of your lawsuit, because that bad side is what you've got to concentrate on. And I do the same thing in private conversations with the other side. And we'll be doing that, based largely on your counsel's arguments that they have provided me and so forth. So I agree with you. It's a difficult forum. It's not one that I am used to. It is, however, what you're stuck with, I guess. And certainly my comments are made so that I get people to take a realistic look at what their lawsuit is. That's what an independent mediator is supposed to do. To be able to step back and say, look, I know you're mad. I know you don't like it. I know that you'd rather fight it out, duke it out, whatever, but I've got to talk to you about what happens in the end. And that's what I just talked about a while ago. So.
Thank you. Ms. Henderson?
Thank you, Madam Chair. Is this on?
Yes.
It is? Okay. I don't know. I'm just having a real hard time, I'm a parent, I have 2 children in the school system, and I just have a real hard time with the fact that, this was never about health and safety. It's clear that it's about control and money, and now I feel like we're just being extorted for more money. And it's $75,000 or $100,000 now. What is it next year when someone else tries to sue for the same thing, thinking, oh, well, we're also going to get $75,000? Or the same plaintiffs who want this again next year. So for me, it's about the year we've lost, but also going forward. It's $75,000 now, or whatever the number may be. But what is it next year? How much money is our school system going to keep losing because people are going to keep suing us over masks?
Ms. Owen?
Thank you, Madam Chair. I think we need to go back to taking the politics back out of this. We've been ordered by the judge to mediate, and to mediate in good faith. So we can give them a different number, or we cannot mediate in good faith. I think that's where our choice really lies right now. It's not about the politics. It's not about what the public is going to say. It's not about that. It's about mediating in good faith. So we can give them a number, or we can choose not to mediate in good faith.
I can speak to that.
Mr. Dupler?
Thank you, Madam Chair. I was just going to speak to what Ms. Owen's saying. I mean, so there certainly is some truth to that. So this board would be advised to come back with something, some type of counter, and I'm not here telling you what that looks like or what that should be, other than obviously you want a dismissal, but you do need to come back with something to show that you are doing this in good faith.
Mr. Watson?
Thank you, Madam Chair. To Ms. Bound's point, one of the points she was making is that right now there's 2 parts to the one motion, and they could obviously be broken into separate. I think that's where she was going with that. But also, too, I think if we don't come back with something in good faith, basically what we're saying is we're willing to roll the dice. And we know that we have a chance of losing, we have a chance of winning in court. And can you imagine what this community would be like if we lost in court? So I'm just saying there's the rolling of the dice if we don't get this thing addressed today, and I don't think that's in the best interest of anybody moving forward.
What's the motion on the floor?
92. Did you want to speak to that?
I want to make a substitute motion that we go back to $75,000 with the stipulation, or with, that this brings the litigation to a permanent halt.
Is the language dismiss? I mean,
Or
halt is.
I'm sorry, to dismissal, whatever the original language was on the first motion that was
Second.
made.
So we have a motion by Ms. Horn, a second by Ms. Babb. Any more discussion on that? Okay. And I would just like to say, going back to what Chancellor Fansler just said, we are at a disadvantage. I feel like we've been at a disadvantage all year. So, if there's no more Mr.
Point of
McMillan.
order, did Ms. Owens' 92,000 not get a second?
She made a substitute
Okay,
motion.
it was substitute. I didn't hear her say substitute.
So we have a substitute.
I'm sorry.
Okay, so we have a substitute by Ms. Horn, a second by Ms. Babb. Any more discussion? Okay, Ms. Coatney?
Miss Owen,
Yes.
Mr. Watson,
Yes.
Miss Babb,
Yes.
Miss Horn,
Yes.
Miss Henderson,
No.
Miss Bounds,
Yes.
Mr. McMillan,
No.
Miss Christie.
Yes.
That's 6 yes votes and 2 no votes.
So, motion carries. Okay, so we will go back in recess. So we are back from recess. Chancellor, would you like to discuss what's on the table, I guess?
Let's see if I know how to use this.
They think it's on.
It's on.
Yeah, just have to.
It's on? Okay, good. I can't tell when I'm on or off here. Y'all hope I'm on, I guess, instead of off. The process, as we've talked about it before, is a give and take, a negotiation. In order for a mediation to work properly, each side has to be willing to concede certain matters and move toward a point that people can either equally dislike it or equally like it. Seldom do I have the equal like it situation. More often it's neither side is particularly pleased with the compromise. It's sometimes a great deal further away than where they started, and sometimes it's not so far at all. In this case, in response to your $75,000 offer, the plaintiffs have responded with a demand of $168,000. That would be a full settlement, and of course, a release by both parties of all claims that exist or could exist as of the date of entry of the order of dismissal. So,
Thank you. Mr. Dupler?
Yeah. Thank you, Chancellor. Thank you, Madam Chair. Madam Chair was asking about, items for discussion. So since this is a continuation of the meeting, with the recess in between, there's already a motion on the floor for discussion and possible action. So you all can continue to discuss, but obviously to make a counter offer of some type, you'll have to make a motion in a second. So thank you.
Ms. Babb?
Yes, I would like for Mr. Dupler to maybe talk us through, if we could not reach a settlement today, what are some of the consequences of that? Because I think that's a big weighing in on this factor of, if we can't reach a settlement, what does that do to the kids in Knox County schools going forward?
No. Good question. Thank you, Ms. Babb. So what happens would be that Judge Greer is the district court judge, and he's put down an order that says that once our excellent mediator, Chancellor Fansler, issues a report, then the mask mandate, according to Judge Greer, would be reinstated. I mean, because it was just temporary hiatus. So there are two motions, one on the board's behalf and one on the plaintiff's behalf, to for different reasons, take away the mask mandate for now, but it would be up to Judge Greer as to when to hear those. So we don't know when that may or may not happen. So technically, if this does not settle today, then once Chancellor Fansler issues his report, then the mask mandate would be reinstated.
Which could mean we would still have masks back in schools for the end of the year, possibly. I mean, we don't know for sure, but that could be a consequence if we can't come to a settlement today.
Could be a consequence.
Thank you.
So, Mr. Dupler, I have a question. So, in terms of attorney fees, theoretically speaking, if it goes to the Sixth Circuit, and I know this was mentioned upstairs, and the plaintiffs should lose, that's no guarantee that we do not have to pay their attorney fees. Is that correct? Did I understand that correctly?
Yes, thank you, Madam Chair. Unfortunately, yes. I mean, with the ADA, Americans with Disabilities Act, there's provisions in that act that if a litigant prevails on, in some form or fashion, then that litigant is entitled to attorney's fees, and that very well would apply here. And part of the argument from the plaintiffs, what we would expect, is that even if we prevail, even if the board prevails at the Sixth Circuit, that the plaintiffs would argue that, hey, I mean, they were successful with a preliminary injunction, so should be entitled to attorney's fees. Does that answer the question?
I guess I have a follow-up to that. The attorney's fees would even be higher than today because they would probably include the Sixth Circuit arguments, correct? Or possibly, there could even be higher than what we're...
Could be. I mean, as a general rule, I mean, the further one litigates, into the process of a case, then fees would be increased.
Thank you.
Mr. Watson?
Thank you, Madam Chair. And Mr. Dupler, I mean, technically, today their fees are increasing as we sit, correct? I mean, in their mind, in terms of the way they're calculating and tabulating, I mean, they're thinking of some hourly rate regardless, correct?
Sure. I mean, any attorney is going to bill at an hourly rate, and certainly, yes, that there was preparation for today, and they're here today.
Yeah, the point being, any work they do on the case, they're going to put that into their calculus of whatever fee they ask for at some
Correct.
future time as well.
Yes.
Yep.
Ms. Horn?
Thank you, Madam Chair. I think in hearing these things, I think that it is important that we consider, and I think that most of us try to ask ourselves what is in the best interest of students when we vote on issues. And so I think that that does weigh very heavily as we are thinking about what could happen, because could you tell me, Mr. Dupler, how long we would expect to hear, what time frame we could be looking at in hearing an answer back from the Sixth Circuit?
Yes, thank you, Ms. Horn. So May 4th is set for oral argument with the Sixth Circuit. But unlike some courts, we would not expect an answer from the Sixth Circuit on May 4th. I mean, what would happen is they would hear the oral argument, they would hear the differing sides from the attorneys, they would ask a lot of questions, the judges would, but after that they would take the case under advisement, is what it's called, and then they would take some time to write an opinion, and that could take, likely 30-60 days at a minimum. Could be even more, could be up to 6 months. So the answer is you would not hear right away from the Sixth Circuit.
Thank you. So I think that's kind of at the point where we are. Do we feel like we want to take control back of our schools rather than it be in the hands of the judicial system? I think is where we've come to today.
Thank you, Madam Chair. I'd like to offer up a motion for the board's consideration in response to the most recent demand that's been presented by the plaintiffs. That motion would be for the case to be fully dropped, that the board admits no wrongdoing, that we agree to $150,000 in attorney fees, and that we split the mediation fees 3 ways between the plaintiffs, the state, and the Board of Education.
Okay, so do we have a second on that motion?
Second.
Could you restate it, Mr. Watson?
Yes, ma'am. That the case would be dropped in its entirety, that the board would admit no wrongdoing in the case, that we would settle on $150,000 in attorney fees, and that we would split the mediation cost 3 ways between the state, the board, and the plaintiffs.
Miss Owen, you seconded. So we've got a motion by Mr. Watson and a second by Miss Owen. Is there any discussion on that? Yes, please.
As a mediator, I deal with a lot of cases where there is what we call fee shifting. It's either by contract in the United States where one party or both parties agree if we have a lawsuit, and the winner then will be able to recover all of their attorney's fees. Or you have statutes. We have Title IX cases, Title VII cases. We have a myriad of different statutes in the state and in the nation where the statute, the law itself, provides for the fee to be shifted. Boards all over this state, over this county, over the United States have to make these fee shifting decisions every day. The bad part of it is that you as public servants have to weigh on yourselves what the consequences of that payment is to the Treasury. And it's a decision that it's not a matter of whether you build a new school or you buy new textbooks or you raise the teacher's pay. This is a burden that's been placed on you by statute that you didn't pass. It's placed on you in a lawsuit that you didn't bring. It's placed on you because of a disease that you didn't create and because of a mandate that is so divisive in this country that families are arguing. People are leaving their churches. It's not a simple issue, and it's a shame that you as our public servants have to be burdened with more than what's the best deal we can get in this fee shifting. I hate that you have to do that, but that's what's been placed upon you. Thank you.
Mr. Watson.
Thank you, Madam Chair. Just want to give a little bit of thoughts behind my motion. So the reason I settled on 150,000 is obviously our first counter was 75 and they adjusted by 17. So I think that tells us that 75 is probably not close to where they're willing to go. So I was suggesting that we try for another 18,000, which gets us to the 150. And then also too, I mean, that's including what I understand the mediation fees might be the ceiling for that. That's less than $2.50 per kid. And I think that's something for us to consider. I know for months now in the public and in this board, we've weighed the disparate impact of this on all of our students. And I think $2.50 per kid is a reasonable amount for us to move forward and to have this case behind us and get on to the other things that I know we all want to be doing as a school system.
Ms. Horn.
Thank you, Madam Chair. Mr. Watson, that motion would double where we started out earlier, so I think that's quite a difference between where we started out and where they came back with their proposal, so I would not be in favor of that.
Is there an amount that you would be in favor of, do you think? I mean, it's hard. I mean, because it kind of does feel like a payment to get.
I mean, we can.
The verdicts.
We
yeah.
can take a vote on it,
Okay.
and somebody
Right.
else can make an
Okay, that sounds good. Ms. Coatney?
Miss Owen,
Yes.
Mr. Watson,
Yes.
Miss Babb,
No.
Miss Horn,
No.
Miss Henderson,
No.
Miss Bounds,
No.
Mr. McMillan,
No.
Miss Christie. That's 2 yes votes and 6 no votes.
So motion fails. Mr. McMillan?
Thank you, Madam Chair. I'll offer a motion that's somewhat less than that, but what I consider reasonable of $130,000.
Second.
I have a question about the motion. Is that the entirety of your motion, or does it involve any other components about dropping the case or anything like that?
Well, it does. It's just, all I'm doing, Daniel, or Mr. Watson, is changing the figure.
So
because
keeping the rest of it the
I
same,
think
just adjusting the
yeah, I
fee?
think that's the big controversy right now among the board members. Otherwise, why, the things that have been discussed, could stay intact as far as I'm concerned.
Can he just amend his to,
So, Mr. McMillan, if I may, so you're making a motion for $130,000, a full dismissal of the entire case. The board does not admit liability, and the parties split the mediator fee, correct?
Right.
And that's seconded by Ms. Owen?
So is there any discussion on that? Ms. Coatney?
Miss Owen,
Yes.
Mr. Watson,
Yes.
Miss Babb,
yes?
Miss Horn,
Yes.
Miss Henderson,
No.
Miss Bounds,
Yes.
Mr. McMillan,
Yes.
Miss Christie.
Yes.
7 yes votes and 1 no vote.
So motion carries. So we will be going into another recess. So we are back in session. Chancellor?
All right, based on the last motion, the vote on the last motion before the board, I took to the plaintiff's counsel an offer of $130,000 in settlement of all the claims relating to attorney's fees, the dismissal of the case in its entirety, including the Sixth Circuit appeal, split the fees of mediation 3 ways, and that the releases would indicate that there's no admission of liability on anyone's part, and that it is a settlement of a disputed claim. Their counter offer was $158,000 on fees, with acceptance of the other provisions. I have, based on experience, been able in most instances to give one side or the other a fairly close projection in my mind of what it would take to conclude this case. And my reading of the other room as such is that this case would settle for $150,000 in the fees. That is a substantial reduction, $35,000 less than they came in with this morning. It's roughly half or better of the previous demands that we're making with the enhancement on the lodestar factor and other things. So there have been concessions made. I know that you feel like a lot of times one side or the other says, I think I'm the only one giving anything here, but based on what's out there, where they started, substantial decreases have been made in their demands, and you're at a point now, I mean, it gets down to a point of, is it worth it to continue to fight this? If $150,000 would settle the case, I mean, there's a lot of things I can do. You could go back to them and say, if the board gave you $150,000, would it settle the case? That's often a situation, but a little different here today, procedurally wise, but certainly it's something you could instruct me to go do. Ask that question, or you can make a counter offer. I'm just giving you my best insight on it. Now, I'm not making a demand for $150,000. You're free to come back with any offer you wish to make. So, if you have any questions, I'll be happy to answer them for you.
Thank you. So we still have the motion for discussion and possible action. So, Mr. McMillan?
Thank you, Madam Chair. In light of what the Chancellor said, I'm going to attempt a figure here that both sides have given up something, and, you know, I think that if we were to reach something, we could leave here, neither side is totally satisfied, and I think that's where we are right now. In light of that, I'm gonna make a motion that we pay $145,000.
Second.
In light of all other things are
And
the
that-
same.
right,
Just
right.
changing the figure.
That would keep everything the same that the
Exactly.
chancellor discussed, correct?
Exactly.
Okay, so we have a motion by Mr. McMillan and a second by Ms. Babb. Any discussion on that? Okay, Ms. Coatney?
Miss Owen,
Yes.
Mr. Watson,
Yes.
Miss Babb,
Yes.
Miss Horn,
Yes.
Miss Henderson,
No.
Miss Bounds,
Yes.
Mr. McMillan,
Yes.
Miss Christie.
Yes.
That's 7 yes votes and 1 no vote.
So motion carries. We'll go back into recess. Okay, we are back in session. Chancellor, you're up. I feel like we're good friends now after.
Well, I'm glad to hear that. Most people say, I'm glad to meet you, hope I never see you again. So,
We think that also.
Not in this setting again.
I am pleased to announce, Madam Chair, that the plaintiffs have accepted the offer as you all extended on the last motion, and the lawyers are in the process of drawing up the necessary papers to have this case completely dismissed against the board, including the appeals process in the Sixth Circuit. And I just want to commend all of you for the hard work and the tough decisions you have made today, what I think is in the best interest of the people of Knox County. Thank you very much. I've enjoyed working with you.
Thank you.
Thank you.
Thank you. Mr. Dupler, would you like to share some of those details we discussed?
I can share one detail, and I agree. Thanks to the chancellor's great working with him again, and he has done a great job in a very difficult setting. One question that the board had and that the public may have at some point is there's one line in the agreement that's being worked on where the plaintiffs are consulting with the CDC and the American Academy of Pediatrics and its own health experts. But that's all it says. I mean, it's just that the plaintiffs are consulting with those groups. To make it clear, this board is not consulting with those groups and doesn't feel that consulting with those groups is necessary. But the plaintiffs feel that way, and that's their prerogative. So that's what there is one line that says that. Is there any other questions on that?
I just have a question.
Yeah.
Do we have to sign this at a certain point, or what's the next step for this board?
Hey, as long as this agreement, which it will, reflects the vote of the board, then the board's already voted, and that's
So we don't need to sign anything?
yeah,
Or
correct. That you have given authority for your representatives, your attorneys, the law director to move forward. Correct. Yeah.
So, anything else? No.
I don't think so.
Okay, meeting adjourned.